Jeff Hood and the Wake Up Show, weekdays on the Legend, WDXE.
Start your days with Jeff Hood when he's here, but he ain't been here all week.
He's not been here all week? I know he wasn't here today, but good morning.
Good morning. Good morning. How's it going?
Can you hear me okay?
I can hear you fine.
I can't hear you in my headphones, I don't think. But anyway.
Oh, well, it's technical.
It's whatever. As long as we're broadcasting.
We are
I can hear you because
broadcasting.
you're sitting right here.
And guess what?
What's that?
We are streaming.
All right. Do you get a lot of folks watching the streaming?
Oh, I believe there's quite a few.
Okay.
Yeah. I've never.
I mean, I think it's an interesting concept. We call it visual radio.
Yes.
They started to come up with this idea. So it seems kind of neat.
Kind of like a podcast.
I mean, yeah. I don't know how fun it is to watch you and me sit here and talk.
Right?
I mean, it may not be all that entertaining, but
It must be because we're still going.
yeah. But no, it's a neat idea. So, hey, good morning. Good morning. Here we are again on Friday morning for Bulletproof Estate Planning. We talk about, guess what?
Estate planning.
You guessed it. Well, you're right. You're on top of stuff this morning.
Yeah.
Although they did introduce Jeff Hood, and he's not here, but we're filling in for him. So, just want to, before I get started, I want to remind folks, because I often forget to do this, that this is a interactive show. We welcome call-ins. We welcome ideas, experiences, just thoughts you might have or something to pass on. The telephone number is 931-766-9393. 766-9393. If you want to share an experience or ask a question, feel free to do so.
Yeah. So
we were just talking about some current events, and we won't talk about that anymore because everybody talks about it. So I want to talk about a few things coming up. I do my seminars, my live seminars, about every other month. Mm-hmm. And I did one in January, and it was interesting. The one I did in January, I had scheduled for a Saturday morning, and guess what day the massive ice storm came in? It was on that Saturday. So we bumped it the next Saturday. We probably got, 75% of the folks that could still make it. And the rest of them that couldn't, but of course that next Saturday was not icy, but it was bitter cold. It was like 12 degrees in the morning. We had a pretty good turnout. It was over at the Star Theater in Pulaski, but several of them just said, I'll come to the next one in March. And that's coming up 2 weeks from tomorrow, actually. And it's going to be right here. It's March the 28th. So, and that's a Saturday, so it's 10 o'clock in the morning.
Oh, they calling for snow on the 28th.
Yeah,
no,
are they?
I'm joking. I'm joking.
We'll just brave the snow then. But,
I'm joking.
But it's, like I said, that's 2 weeks from tomorrow, and that's going to be right here at the WLX radio station in the back of the building, where we set up and do it. So, if you're interested in coming to that and you're listening to me and you're not from Lawrenceburg, the physical address is 1212 North Locust Avenue in Lawrenceburg. GPS will bring you right there. The name of the seminar is called Will's Trust in the Nursing Home. And that's what we talk about. So I'll do my next one in May, every other month. Mm-hmm. However, I do have one scheduled in April, but it's not really one of mine, but I've been invited over to Marshall County. Marshall County invited me over. We're going to do it at their library, over the public library. And that's going to be April the 25th, which is a Saturday, when the girls were trying to set it up with them, because it was a special invite. We were more than happy to accept that invitation and go over there. And they kind of said we were so used to Saturdays at 10 o'clock, that's what we ended up getting. So that's what we're going to do over there on the 25th of April. Same seminar, Will's Trust in the Nursing Home, but it's going to be at the public library in Lewisburg in Marshall County, which is, I think the address, if memory serves me, is something like 310 Old Framingham Road in Lewisburg. Mm-hmm. So I'll get that exact as we get a little closer. Maybe some folks are somewhere between here and there that might want to go to that one instead.
Yeah.
But again, it's the same seminar. You're going to hear all the same information, but it's not one that I'm sponsoring and putting on like I do when I do it here, do it at the theater or up in Franklin, that sort of thing. So just another choice for folks to come to. So anyway, I'll bring all that up again at the end of the show.
Okay.
So we're going to talk about stuff estate planning. I like to go over some events, things that happened in the office lately, or if something happens in my office that a couple of times, 3 or 4 times, it's something I like to bring up and say, I see this from time to time in my office, and that's sort of how I wanted to start. And now, one of the things that came up, it surprises me how often this comes up. When I give you the story, the facts, you'll think, how can that happen? But it really happens kind of often. And there's 2 cases where folks came to a seminar and they wanted to do a trust plan. And we sit down, and of course, if you say you want to do a trust plan, we will set a meeting. We call it a family vision meeting. Now, the way it works is you know, I offer that time at no cost if you've come to the seminar. But I also have a pre-recorded, or I mean a recorded version of the seminar that we have on YouTube that I'll be glad to send if somebody can't make the actual live seminar. It's all the same information, it's just a PowerPoint on the YouTube. You don't get the pleasure of me talking live, right? But it's all the same information. But if you've done that, there's some sort of pre-education in that seminar. And so if you schedule a family vision meeting, you know, that's something we'll schedule for you, and then we'll do a sort of a deep dive in, you know, because I talk about several things at that seminar, and most people gravitate toward one thing or the other. And so when we get in there, one of the first things we talk about is, you know, are you leaning a certain direction towards, you know, our irrevocable living trust or our asset protection trust? And most people are, and so we spend the time talking about that. Now, when I'm doing this deep dive, we talk about two cases in particular. We're talking to a gentleman that was wanting to do it, and so when they said they want to do it, you know, one of the things we like to do when you have a trust is we like to move all your real estate into it. And you know, certainly your home, and some people, you know, they have a home, but they may not have other real estate. But if you have other real estate, we like to move it in for you, and we do that for you. We will do the deed. Okay, so we had a gentleman that wanted to do one of our asset protection trusts, and had his primary residence where he lived. You know, gave us the information. We made a copy of the deed, and so we go to draft a new deed to put it from him to his trust, right? And we want to get it in the trust. So when we're doing that, lo and behold, we noticed that it was still titled to him and somebody else, a female. And we figured it was probably an ex-wife, and I don't remember if we talked about that, but we get him on the phone, and he said, "Oh yeah, I've divorced her. You know, we're divorced." And I said, when was the divorce? And he said, "Oh gosh, it's like 30-some years ago, 32 years ago." And so we thought, okay. So I was a little perplexed as to why her name being on the deed is not what concerned me. Usually, the name of a spouse stays on the deed after one of them passes away. I get a call often that says, "Hey, my husband passed away or my wife passed away. Do I have to change my deed? Just show me." The answer is no, you don't have to. If something happens like a sale or a change of ownership to a trust or something, it'll get fixed at that point. But what really happens is if that person passes away, then all ownership vests with the survivor, especially if it's husband or wife. So there's really no need to change it. But when we do deed the property, we make reference to that death. So in this case, it just perplexed me because if it was a divorce, I would assume there'd be what we call an MDA, a marital dissolution agreement, which is when people get divorced, there's certain things you're supposed to do. And that just depends on whatever, you know, what was going on with the marriage at the time. And so it was 30-some years ago, so we had to go to the archives and dig it up. Okay, we did. We found a marital dissolution agreement. We dug it up. And this is like the second case I've had that had this kind of similarity. Well, there was a couple things that needed to have been done back then that the husband was supposed to do. And if he did that, then the wife it said in the order of the court that the wife would then sign off on the deed. Well, the person could barely remember, but apparently it didn't get done. And so it was still titled in that name. And now, in my opinion, that's kind of like their attorney's fault, in my opinion, because they should have followed through with a court order.
I was sitting here thinking that, but
a court order is an order from the court, and if you get an order from the court saying to do something, you need to take that very seriously, because if you don't do it, they can hold you in contempt of court order, and this court takes that very seriously. I mean, they have to show that that's not something you can just blow off, and so when they do that, it's very serious. They'll hammer you with some sort of punishment for that. Contempt can carry 10 days. And because, the court can't let it out that they're soft on you. Oh, we already do something, but it's okay. It's just a suggestion. You can do it if you want to know. It's not like that. And so I get back to them, without getting into what had to be done, usually that's kind of the way it is. They'll say, if you do this and that, maybe when you make your first alimony or spousal support payment, then she's supposed to, within 60 days of this order, they'll sign the deed over to you. And we found out that never got done. And so it's 30-some years later, so we reach out to the person that didn't sign the deed, and they kind of said, well, really, am I still on it? Well, I kind of think I might want to hang on to that.
Oh, no.
I don't know that I want to actually just sign that off on that. So what I kind of got them together and said, look, as far as I'm concerned, you're both in contempt, and you do not want this coming to the court's attention, because they will take it very seriously. So let's just go back in time and do what we were supposed to do, because, you know, if you do it 30 years late, at least we still do it. And nobody can really complain about it, because if somebody's late doing something, the time to complain about it has come and gone. And if you don't complain about it, you sort of accept what they did or didn't do by, I call it acceptance by acquiescence. You know, if somebody's, if they had 60 days to sign this thing, and then on day 61, you should have been in court saying, hey, if they've had 60 days, it's over, I want this done. But it's all 30-some years later. And I said, just do what you should have done and just be done with it. Because, you know, you have to take the position that you were all both willing to do it, then you agreed to the order and the court entered it, you know, so let's just do it. So, but it surprised me that was, and during the whole time we were talking to the fellow, nothing like that ever came up. It came up when we took the deed and we found that person's name on it, and kind of Sherlock Holmes did a little bit, and we found that out. Another case along the same lines was, same thing, we found out that the person had a spouse, and it was on a deed. That's how we found out about it. And this case is a little different, because when I approached the person, they said, oh yeah, I mean, I was married to that person, but you know, like 20-some years ago, we just agreed to call it quits and walked away from each other. And so I asked, I said, did you get a divorce? Or I asked, I said, was this a statutory marriage? Meaning you go to, you know, get a marriage license, right? And they said, yeah, we did all that. And I said, well, there's two remedies to a statutory marriage. One is death, or I mean, there's only way to get out of or stop a marriage. One is death and one is by a statutory divorce. And they were both living, so I said, did you have a divorce? And they said, yeah, we divorced. And I said, well, okay, so you went divorced, you got a marital dissolution agreement from the court, and all that. So no, we didn't go to court or anything. So I'm thinking, okay, I need to find out what's going on with this. And he pretty much said, we just called it quits and decided to just walk away. And we did. And he said, is that a problem? I said, well, it is if you pass away, it is. Because now we want to put your property in a trust, and we can't do it because we have to have all the owner's signature. Because now it wasn't a case where there was a court order saying that the one person would have signed off on it. They were still owners. I said, listen, here's what's going to happen if you pass away. Let's say you never came to see me, and nobody ever knew this was here. You pass away, your kids are going to experience this spouse of yours surfacing somewhere and with their hand out. It says, I still enjoy the status of spouse. That's a legal term. Spouse. And if you're the spouse, then even if you have a will giving everything you want, because that was the question that came up, well, can't I just do a will or a trust that gives everything to my kids like I want to do? I said, you can do that, but here in Tennessee, we have something called elective share, which means a spouse, I say it this way, you can disinherit your children, but you cannot disinherit a spouse, because if you even say in a will or trust that I leave nothing to my spouse, or are silent about your spouse, like this case would have been, because they couldn't even remember they were together anymore, they can exercise elective share, which means if you have a long-term marriage, which is defined as 9 years or more in Tennessee, don't ask me where they come up with that odd number, but they do, that's considered long-term, and that means, depending on how long you're married, up to 9 years, they can get as much as 40% of the estate of the deceased person. Now, it works for woman to man or man to woman. Elective share works for both. Now, and that falls right in line with our laws of intestate succession. You know, if you pass away without a will, then automatically the spouse gets a third or up to a child's share. Now, that's weird language, because the only time it wouldn't be a third is if you had one child, in which case it would be a half. But as soon as you have a second child, now they get a third, and the other two kids get a third. If you have 5 children, the spouse gets a third, and the other 5 children split the other 2/3. You know, if you have no will at all. But even if you have a will and you leave it to them, they can insert themselves because you were married, and it's considered offends public policy to not leave anything to a spouse at a death. And there was no statutory divorce, so they were technically still married, and she had that. In case it was she had the status of spouse, and she could have done that. So we had to negotiate something. And I remember that case, it was still pretty much they didn't want to do it. I mean, they weren't hateful to each other, but it was like they were both surprised that they were considered still married. And if I'm thinking right, I think the spouse that we reached out to had remarried, if I remember right, which jeopardizes that contract. Because if you're married, you can't enter into a contract for another marriage. Now I said, you know, I think there's an issue there. You might want to get an attorney to look at that. You know, if we agree to do this, maybe there's an exit ramp that keeps it so that you can keep the contractual marriage you have. But if you don't, you could just quietly go to a justice of the peace or even a county commissioner and just quietly get married again, and then it's kind of seamless to everybody else and stuff like that. Even though, but anyway, it surprises me in how often. I mean, if it comes up once in a year, that's kind of often for this sort of thing.
Yeah.
You know what I mean? But I've probably seen it. Oh, last year I think I've seen it 4 or 5 times, and this year already twice. The rolling into March.
Huh.
And so, it's just, I don't know, nobody's real fault, I guess, but just maybe not knowing what the effect of that is. But I mean, it all got cured because they wanted to do some estate planning. We do some estate planning. We do that deep dive. We look into everything, and if you want to put your property in, we'll put it in. But and I actually do that for them. I write that deed. But to write that deed, we do we go back and look at the predecessors and title and make sure everything's okay. And that's where we find that stuff. And it's just, it's always a fun time when I have to notify them of that. Because I remember telling the one gentleman, he said, "We've been apart for 32 years." And it's like, I know, but has it got a legal problem here?
Yeah.
So, talk about coming back to haunt you, or what is it, coming back to bite you somewhere?
Yeah, absolutely.
Fortunately, they worked out pretty good. The one I thought, oh great, this is going to be problematic, because she said, well, I think I might just want to hang on to my part of that land.
Yeah.
And it's like, no. So they worked out pretty good. So I was glad for that. So, that's, if nothing else, estate planning is a good way to make sure those affairs are in order, because if something happened to you and you pass away, that's going to be a big surprise to your kids or your heirs when that happens, and they're not going to be very happy about that at all.
I wouldn't either. Hey, we got a call coming in.
I didn't even hear it ring.
Good morning, WDXE. You're on the air with us.
Okay, can you hear me?
Yes.
I want to throw out 2 or 3 things. I wonder with Mr. Pierchoski if it has to do maybe with so many people moving here or back here. I've had several situations I wanted to throw out, and he won't have time to cover these. But one has to do with somebody that's moving back here that will have a will or an estate, I don't know which, in another state, and I know he says they can handle those, but a lot of time what happens is there's something that might be legal in that state, but here, I was actually checking on the thing in Alabama with the marriage, and by the way, common law down there has to really be documented. I mean, it's not just somebody says they've lived together, but they've got a lot of written documentation with the courthouse when they started and the documentation they have that they've been husband and wife. But I wanted to throw this out, and okay. Out-of-state wills and trusts, this is my concern with a friend that's moving here. I know she had complications there. It just seems to me someone called in on Dave Ramsey, and it fell into this thing. The lady was reluctant to marry this man because of the will or the trust, because she had a life estate, and one of the points he made is, well, be careful, because you don't want to be landlocked if he were to die and it went to your children or whatever. I just thought I'd throw that out. He might think of some other things off those topics.
All right, we appreciate your call. All right.
Well, I was trying to take some notes. I'm in a little trouble with the second half of that, but let me deal with the first half of it. And I think someone called in last week or the week before recently with kind of the same question. So let me make sure I'm getting an answer out there. Maybe my answer wasn't too clear, but basically, I guess what we're looking at is a situation where somebody has some kind of planning. And planning could be a will or it could be a trust, and whatever it is, they have it in a different jurisdiction. The jurisdictions I'm talking about is the 50 states, right? Mm-hmm. And let's say they come from, I was going to say New York, but I don't like New York, so let's say
Portland, Oregon.
Portland, Oregon. I don't like that either. Let's say comes from Arkansas, Little Rock. Okay. Come from Arkansas, and you migrate to Tennessee, and you decide I'm going to live here. And you gain residency here, and you're going to stay here for a while. But all your planning is from another state. Now, the first thing they need to know is a lot of people will call me and say, "Hey, I moved here, and I have this trust or this will. Do I have to change it now because I'm in Tennessee?" Mm-hmm. The answer is technically and legally no. It's not invalid just because you changed to another state, because in the United States, you can freely move about from state to state, and because of that, in our Constitution, the original Constitution, not something that was added, but in the original Constitution, it says that all the states, all 50 states, will give all the other 50 states what is known as full faith and credit, which means they will recognize that state's jurisdiction. Now, but it will still be governed by that state. In other words, she mentioned if something's legal in one state and you come here and it's not legal here. Well, if you come here with an Arkansas will and you're living in Tennessee and there's something at death the trust needs to be administered, right? Well, it gets administered under Arkansas law. Now you can do that here. That's what full faith and credit means. You can say, okay, we're going to do trust administration, or maybe a better example is a will. You have a will and it has to go through probate, right? If you open up probate, you can do that here in Tennessee, but the laws of Arkansas are going to apply. That's what full faith and credit means. We will give that state's laws full faith and credit here in our state. And so if something's legal in Arkansas and you go to probate and you're using probate from Arkansas law, then it's okay because there's no change. Even though it's not legal here, I can't think of much would fall in that category. But that being the case, it's still legal because we're giving full faith and credit to Arkansas's law, which does recognize whatever it is as legal. So that's not a problem. It's okay. Now, a lot of people will change it because they just feel like, because I'm here in Tennessee, I probably should have a Tennessee will. Again, you don't have to change it just because of the fact that you moved. Now, so if you did a will and a month later you moved, I mean, it seems like a kind of a waste to redo it again because you would have paid for it, right? You'd have to pay for another one. So it's not really necessary, but some people just feel better if it is that because okay, we're going to be here for a while, or we're leaving Tennessee, so. I feel better if it's a Tennessee thing. Now we can do that too. You can a will, you just write a new will. Trust, we can do a restatement which changes the situs of the trust and stuff. So it can be done. But the point is, it doesn't legally have to be. Now I don't do probate anymore, but when I was doing it, I many times probated another will from somebody that traveled here. The reason I said that about New York is I remember doing one from New York and it was just a pain. But you can do that, and I've done it. So that's not a problem. I think that answers that question. Now, I'm sorry, but I just got lost in the second half of that question because there were some terms that were very inconsistent, like talked about having somebody getting remarried and they didn't want to get married because of a will, and somebody told them, be careful, you don't want to get landlocked. The term landlocked really talks about easements and land that doesn't have ingress and egress ability, but there was talk about a will and stuff. So I'm not really sure what that was. Maybe if you want to call back and make that a little clearer to me, I'd be more than happy to answer it. But I don't know why somebody would not marry somebody because of their will. I mean, if you're going to marry someone and you already have a will, let's just suppose, chances are very good that it's a blended family situation.
Yeah.
And I would expect them to have a will and want to leave it to their children and stuff like that. So, but anyway, maybe there's some. It's not ringing, so.
Good morning, WDXE. You on the air with us?
Yes, it had to do with somebody wanting a prenup, and the family wanted to write it where they bought the land, but they kept the right. The spouse would be able to live there, but they had the right if he died for her to live there with a life estate. But when he was saying that, it has to do with people. They want the property next to them, but they wanted to make sure she wasn't in a situation where she would be tied to that land to stay there. And when I said landlocked, I mean in terms of, that was not the term. In other words, she couldn't sell the land, and that's what she wanted to do. But the other one had to do with what's illegal, and I want to throw this out. This is way, if someone were doing a trust, you said they can put anything in a trust they want to. There is a bill in 11 states, including the District of Columbia, saying that the patient can give themselves this prescription when they have 6 months to live. Now, if someone put that in a will or a trust in another state, and they moved to Tennessee, and they put it in there saying, if my children if anyone named in this will or trust does not allow this, they are disinherited. I would think in Tennessee that would be illegal, but in another state it might be legal. And this may be way off base. I just think this is relevant in somebody. I don't know the person, but anyway, I just want to throw that out, and it may not be relevant here.
Okay, all right, we appreciate it. All right. That
All right.
clear it up any?
Some. Okay, talking about a prenup. A prenup is an arrangement when you marry someone that you have property going into the marriage, and you want to, and a prenup is really only a valid document if in the future you get a divorce. You know, in other words, it's anticipating a divorce. If there's a divorce, it dictates where the property is going to go, rather than go to court in a divorce court and make the property division subject to the jurisdiction of the court. You're deciding where it goes up front, and it's an agreement like anything else. So if you agree to it, you're stuck with it. And if you don't want to agree to it, don't do it. Now, that may jeopardize the marriage, but that's the way it works, right? If you say, I'm not going to sign that, then the person says, well, then I'm not going to get married. All that's okay to say and do. I mean, that's an agreement. So you can negotiate it like any other contract. So they have a prenup, and now, so the property is never, like let's say it's real estate. You have a prenup, say this is going to stay in my family because that was why we bought it, long before we had this marriage. And so if you have the prenup, you know you're not getting the property. But they might say, you know, because we're married and all that, if I pass away first, you can certainly have the use of it for the rest of your life. You can live there. That's what the life estate is. You say, okay, if I pass away first, my wife has this life estate in this property, and she can live there for the rest of her life. Now, she said something about not being able to sell it, and that's exactly what the result of that would be. Because when you have a life estate, what you're saying is I own this land, and at my death it goes to my children. But when it goes to my children at my death, I want to expressly reserve a life estate for my spouse. So the deed goes to the children; they own it. All you've done with the life estate is you've retained for this person the present possessory interest, which is just one of the rights you have when you own property. And you don't own it. You own the life estate. You own the right to live there for the rest of your life. And you can really live there as right. And what goes with that, if that person ever does sell the property, whoever buys the property has to honor the life estate, no matter who it is. You know, let's say you have a piece of property there and the kids own it and they sell it to some industrial complex that wants to build a factory there. Well, the people that buy it can't build that factory if the person's still living there in the life estate. They have to wait it out. It's kind of like a easement or restricted covenant. A life estate runs with the land. But anyway, so that's exactly right. If they have a life estate, do not have the ability to sell that property. You could sell the life estate. The only problem with that is nobody would buy it.
Yeah.
Or, I mean, because nobody knows how long you're going to live. The only person that would buy it would be the remainder and the people that actually own it, just to eliminate the life estate. But you don't have the right to sell, to redeed the property because it was never deeded to you. The only thing that was deeded to you, what was in the deed expressly reserves the life estate for you. It's an old common law form of action. It's been around forever. And there's times when you should do it and times where it may not be the best of ideas. So, I think that covers the life estate and the prenup and stuff like that. I mean, that's very common with blended families because people have a lifetime before that where they accumulated property and they have heirs. That the thought theory was, I was always leaving this stuff to my kids. But if they decide to get remarried and that person has kids, you want to keep that stuff property. Because now you're kind of going to, if those folks are remarried for any length of time, your property sort of starts to become mine, yours, and maybe some of ours now. Just like kids, you know, you see blended families, you know, you got the husband has some kids, the wife has some kids from before, and maybe, depending on when it happens, they have a child that's now a joint child between the two of them. Property is the same way. And some people say, well, if I get remarried, I don't want all the property going to my new husband or his children. I want my children to get what they would have had, what I always had in mind. It makes perfect sense.
Oh yeah.
And the prenup is a good way for that. But again, the prenup deals with a future divorce, not a future death. So if you pass away, and again, if the property division is settled with the prenup ahead of time, but it can only cover what you have at the time. It can't cover property you acquire in the future. You could add that to the prenup. There's also something called a postnuptial that you can actually enter into after you're married. Same kind of thing. But it's all, again, the key to a prenup or a postnup is it's all by agreement. You don't have to agree to anything. People say, well, I had to sign it. Well, it's like you had to sign it for the person to marry you. You know, you have somebody that's got a ton of property, it's ancient property that's been in the family for generations or something, you know, one of those farms, they want it to stay in the family, and it's that important to them, and you say, I need you to sign a prenup so that you can never own the property. You know, we can use it for our income, and you can have money from it, and you can even have a life estate to live there, but you can't ever have it because it has to stay in my family. and they say, well, I don't want to sign that, the person could say, well, then we're not getting married.
Yeah.
And they'll say, well, I'll sign it because I want to get married. Well, they're not making you sign it, it's an agreement, you have to agree. And once you sign it, this is probably obvious, and maybe I shouldn't have to state the obvious, but if once you sign it, it is never a defense to come back and say, well, I didn't know that's exactly what it was going to do, or they made me sign it. You know, if somebody made you sign something, you have to prove it. You know, and of course now you're talking about duress and stuff, and it's not duress, or they're not going to marry you. I mean, maybe seem like it at the time, right? But that's not the duress we're talking about. It's legal duress or coercion, stuff like that. Look at my own writing. I've got my glasses. I do have my glasses. I think that. Oh, I know it. The last part was the part about the. She said I said you can put anything into a trust you want. Now, of course, you can put anything in a trust that you own. You can't put. If you're getting Social Security payments, you can't put your Social Security payments in the trust.
Yeah.
I mean, you can put them in a bank that's in an account that's in the trust. But you put stuff that you won't, because you don't own those payments until they get there, okay? Like a good example of what you can't put into a trust, if you say you have term life insurance, you got a $300,000 death benefit, you don't own any of that. You have to die for somebody to get the $300,000, so you have no ownership in that death benefit, and so you can't put it in the trust because you don't own it. What we can do is say, okay, I'm going to make the trust the beneficiary of it, and then in the trust describe how the $300,000 is going to be distributed, stuff like that.
Yeah.
But she was talking about something I'm not overly familiar with, which surprises me because I like to think I'm familiar with everything, and that is some kind of assisted suicide or some. I don't even know if it's assisted suicide, but something that would hasten death, right? I don't know that's really legal anywhere in the United States, but it may be. Okay, I don't keep up with something like that.
I don't either. I don't
but
know.
I don't know. But I can see the dilemma it can create. Let's just assume. You know, I was talking about Arkansas. Let's assume in Arkansas you can do that. You say, you can dictate terms that say, if I am of this kind of medical state. To be honest with you, I can see a couple things happen. If I'm of a certain kind of state, I'm allowed to take something to hasten my death. Well, you don't need the law to say that. You can do that anytime. That's called suicide, right? You can do that to yourself anytime you want. It's kind of against the law, which is kind of odd, but you're not expected to do that. But I think she's talking more like if I'm of a certain medical state where I couldn't do it for myself, but I wanted it done. I can put terms or conditions in my will or my trust for my children to do that. And then go further yet and say, because I want that done, if I put terms and conditions in my trust or will that says, if you don't do that, you're going to be disinherited. Don't know how to talk about it too much. I'll look into it if I can find some time to do that. But one thing about putting terms and conditions in trust, I often say you can put any terms and conditions in trust that you want, absent an illegal purpose. So really, I think putting that in there would come down to the legality or the illegality of it. Now, that sort of gets complicated with what I just said not too long ago about full faith and credit. If it's illegal in one state and now you're in another. If I'm just doing a legal analysis in my head, it would tell me that if it's legal in Arkansas to do that, and you put it in your trust, or your Arkansas trust, and move to Tennessee, and Tennessee will give full faith and credit to the Arkansas trust, legally it seems to me like we would have to honor that, because you're not breaking Tennessee law. But you're here, and if it's a law, or then you're subject to the jurisdiction of our law if you're just here. So an interesting question.
It is.
I don't know anywhere that it's legal, but I'm not going to say it's not because I don't follow that. And that's 49 other jurisdictions that it could be in. So again, it's not really assisted suicide, but it's getting close. But it's anything. It sounds like anything you can dictate to hasten your death. Because there's the old legal bar exam question that talks about anything you do that hastens death, it can be considered murder. And so the question is this. Suppose a guy's on a 20-story building, and he says, "I've had it. I'm jumping." He jumps off the building. He's falling. He's 20 stories. He's falling to his death. When he hits the ground, it's an absolute, positive assurity that he will be dead. Right? And somebody's on the second floor, and as he falls by, the person on the second floor takes a gun and shoots him. And that bullet goes right through his brain and kills him instantly before he hits the ground. And the question is, did you murder that person? Now, I get the argument, the immediate argument, well, he's going to be dead anyway. But the law says that that act hastened his death, sped it up. So when you know, a typical lawyer would say, well, if you speed it up, what if we speed it up by 1 second, you know? And that's punishable because of that. That's the concept. So I'd like to see what states can do, if they can do that, and what that hastening death means, and who's allowed to do it. I find it something that the court might say offends public policy if you're making someone else do it and conditioning them doing it on the inheritance. I don't know. I mean, it's never come across, which intrigues me when something comes up that I've never had to deal with. I know we can't do that in Tennessee. That's those rules. We have laws against assisted suicide. So I don't know. First of all, I'd like to find out if it's legal in another state, and then find out what it is they let you do in that state. Because that brings up a whole other question. Suppose you allow assisted suicide. Well, what's the assisting look like? That's kind of a wide term. Shotgun to the face. I mean that's assisting, right?
Yeah.
Some like the Kevorkian did, some kind of poisonous cocktail.
Yeah. That's
painless and more humane. I don't know. I mean, I'd have to know what's going on. I do know that if it offends public policy, the states do not have to honor that. Let me give you an example in estate planning where that exists, and that is we do an asset protection trust, right? And you can protect your assets from creditors and stuff like that. However, if Nevada, which is a state that they call it Sin City, right? It earns its reputation that way. And Nevada had rules that say if you can even put property in an asset protection trust, and you can avoid alimony and child support. Now, some years ago, maybe 10 years ago, this came up in a court case in Utah. In Utah, it was the same thing. We're giving full faith and credit to Nevada. They said, however, we are not giving full faith and credit to avoiding child support or avoiding spousal support because that offends public policy, and we won't honor that. So if it offends public policy, so I'm thinking it might fall on those grounds because you could say something like, well, in this state it's allowed to discriminate on the basis of race. Well, you come to Tennessee, and Tennessee says you can't discriminate on the basis of race, so that offends public policy if you do discriminate, so we won't honor that. There is that off-ramp for them, or absolutely illegal purpose, and that would be an illegal purpose. So it might fall into like something like that, but the Utah said, if we're not going down this, something that offends public policy is what they call a slippery slope. So meaning if you're going to father children, and you can just get out of paying it by doing a trust in Nevada, you have an obligation to take care of that child. And if you don't, then that child's going to become a ward of the state, and if there's no check and balance on that, it's going to become a problem throughout society. So they're saying, if you father a child, then you've got to support it, or mother a child. You have to support the child, you have to take care of it, just like any parent does, whether you want to be the parent or whether you wanted that child or not. I mean, that's been that way for centuries, right? And so the Utah court struck down the provisions in the Nevada trust code that says you can do that. To my knowledge, Nevada's not changed that. I know somebody in Nevada, maybe I'll ask them that, but they've not changed those provisions because in Nevada they do honor it. But but if that's the case, then people are going to go to Nevada and open up a trust so they can't avoid child support and stuff. And I'm all for that because what that created was the term super creditor. Super creditors are child support, spousal support, bankruptcy, and everybody's favorite organization, the IRS.
Yeah.
I mean, those are super creditors that you cannot bar them just by having a creditor protection trust. And when you think about it, it makes perfect sense, right? I mean, I don't think it's good for society to divorce a spouse and leave them hanging when they spent last 20 years being a stay-at-home mom and wife, and then you just decide you don't care for them anymore, you divorce them, and now they have no work skills, no ability to take care of themselves. I mean, those spousal support laws are for a reason. They're not there for the fun of it, just because we think you're going to make you pay money to your spouse. There's a purpose for it. Same thing with child support. There's a purpose. I mean, if you hadn't got divorced, you would take care of that child until they're old enough to take care of themselves, right? So just because you decide you don't want to be married anymore doesn't relieve you of that responsibility. So I agree with that. Same thing with bankruptcy. Bankruptcy is an interesting thing. It comes all the way back from our scriptural law, bankruptcy. And it's a relief you can get, but there's some responsibilities associated with that relief. You can't just screw over creditors, because that's what bankruptcy does. It kind of gets you out and gets you out from one of these creditors, so you can have another chance to try it all over again. But there are certain rules you got to follow, and you can't just opt out of those rules just because, you know, it's self-serving when you do that sort of thing. And the IRS, well, they have their own reasons. The same thing, it offends public policy. So all in all, I'd have to research that a little bit, but I think that's probably where it would land. The state that has to honor that could consider that as offending public policy to the point where they might not honor it. But I don't really have an actual answer to that. Not sure why anybody would want to do that, but I guess there's, you know, people that get sick and painful and have their life is very unpleasant, and, you know, I don't know. I'm very Christian based, so it's hard to comprehend that stuff. But being a Christian, it's hard to comprehend a lot of things that happen in the law.
I've got another call.
Okay.
Good morning, WDXE. You on the air with us?
It's me, and I'm not trying to monopolize, but it's called the Death with Dignity. Death with Dignity. And it's where the doctor and the nurse don't administer it. If a person is given 6 months to live, there's nothing else we can do. Then the patient can do it. Well, I did patient advocacy a while back, several years ago, but I have known people that have been given 6 months to live that lived 12 more years, that lived 20 more years. My husband almost lived 3 years with 6 months to live. The second thing is I think it ties in with this, where with the Roe Wade or whatever, and now they're bypassing that bill with spelling abortion things through the mail, bypassing somehow. But the thing is, patients that are given that diagnosis have PTSD many times. I've seen that personally. If you're given 6 months to live, well, nothing we can do. Number one, you're not in the mental state to make major decisions. I just wanted to throw it up because I even went to it was brought up in the Tennessee legislature the last year, and but the problem is you may not understand, or the doctor may not understand. I just wanted to throw that out and research what I'm saying. I could be wrong, but I'm pretty thorough on things like this. And I'd like to know if I'm wrong. Thank you.
All right, thank you.
All I can say to that is I will if I have time to do it. It happens so rarely. I don't know that. I mean, I could probably learn it, but I'd like to learn things that would be useful.
Yeah.
I'm not sure that would be, but it is intriguing to me.
Yeah.
So, again, Death with Dignity talks about death. It doesn't talk about killing, and that's what that is. There's no way around it. It's not. But again, a patient could do that to themselves anytime they want. So the only time it could really enter the law is if you're bringing somebody else into the mix to participate in some way with it. I mean, you know, I don't. It's not that I have a right or anything, but there's nothing to stop me from taking my own life at any given time if it's my decision. So, again, where the law would have to enter that would be if somebody else is getting involved. And now it's real similar to our advanced care directive, where if our advanced care directive says you can choose now that if you are in a brain dead vegetative state, you're in a coma, and if you need any of the life sustaining measures, like resuscitation or ventilator or something like that, do you want it to stay alive in that condition? You can choose not to have it. Now that's choosing not to resuscitate, not necessarily choosing to take you out. And one of those things is a terminal illness. If you have a terminal illness, if you look at your Tennessee Advanced Care Directive, it says if you have a terminal illness, and they define that as having, or end stage illness it's called, it's defined as having a terminal illness where you're not responding to medication or treatment. If you have that, the question is, do you want to be resuscitated with a life-sustaining measure if you need a life-sustaining measure, yes or no? And again, if you have it, nothing applies until maybe your heart stops, or you go into a coma, or you have to be kept alive with feeding tubes and stuff like that. Then if the choice is no, I don't want to be kept alive, then they just don't do that life-sustaining measure, and you just may or may not expire from them not keeping you alive. So, but that's not hastening to death. That's just not doing anything. And that's as far as most states really go that I know of. But Death with Dignity, I'll look into it and see, because it may come up someday, and I would like to know.
I'm gonna have to step out. You just go ahead and keep on doing doing your thing. I'll be
You could
right
have done
back.
it without mentioning it, and then I can talk and be the only one in the room. I'm good at that. So, all right. So hopefully, I'll see what I can find on that. It is definitely an intriguing question. I kind of hope I don't ever get approached with that, because I mean I have a moral sense about myself and would not want to have to give any advice on that. Anyway, so all right. So hopefully that answered all the questions. Now I want to bring up a couple of things, and one is sometimes I keep everybody posted that we have. We do not only we do a lot of trust planning for folks, we also do 10-care eligibility planning. And we have a crisis team that deals with that. And the 10-care eligibility is not somebody. It could be, but typically it's not somebody who has done planning and done a trust, and then they go into care. We have that too, but we call it crisis planning because people will come to me and say, "Hey, my spouse has just got admitted to the nursing home, and what do I do? We have all this stuff we earned in our lifetimes, and we own our house, and we own our money, and we hate to lose it all." And we call that crisis planning because somebody's already in care or very close to going into care, and now they want to do some planning to protect everything. If you do the trust that way ahead of time, like the asset protection trust, you're going to be about 7 out of 8 steps, 7 out of 10 steps towards eligibility when you get there because of the trust. And then we just have to finish it up to get you eligible, which is relatively easy that way. But in crisis planning, nothing's been done, and we have to deal with it all. And we call it crisis because we have to deal with it, and we have to deal with it in a pretty quick manner. Time is now a major factor. That's why I give it the name crisis planning. Because usually the people that are in care are financially bleeding to death to the tune of whatever it is. I mean, last I looked, it was like $330 a day or $10,000 a month. There's already been a change in price in the month of January, so it's just going to go up from there. So we have several of those cases going on at any given time, and we had 2 of them. One of them was not problematic at all. We filed the case, and 3 months later they gave us the approval. Really no hiccups or bumps in the road on that. Everything went exactly as planned. But it's always a good day to be able to tell the family that we got the approval. One of them was one that did have a couple of hiccups, so we were struggling with it. We were arguing with the Take Care folks, and it took about 6 months. But the 6 months was just this week, and we got the approval. And it turned out the approval we got was just the way we wanted. There was one fair hearing in that, and we were successful with the fair hearing. And so we finally got the approval on that one. And again, it's always a good day to call the family and say, "Hey, I know it's been 3 months or 5 months or 6 months, but we finally got the letter today for granting approval." And that makes them happy because, they're in the nursing home for 5 or 6 months, and the nursing home is saying, "Hey, you're not paying us." And I always tell them, "Hey, we don't have to because we're application pending. So stop asking us to pay because it's against the law for you to ask us to pay." People say, "Well, why?" And they always say, "Why is it against the law?" I say, "Well, it's not my job to tell you the law, but since you asked, think of it for a second. We're getting this person eligible by changing their assets. They got to have less than $2,000 of accountable assets to be eligible, and we've done that. If you force them to private pay, then when they get approved, which I know they will because it's my case and I've never failed to get anybody eligible yet, they'll go back and pay the nursing home everything from the day we filed the application forward, which means the patient would have overpaid. And they'll say, "Oh, but we'll refund it to them." Yes, but when you refund it to them, you just over-resourced my client. I just spent a lot of time, energy, and effort, and they spent money getting me eligible, and you just scrapped it all by giving them a $30,000 check. Here's your overpayment. Now I have a patient that's supposed to be below $2,000. You just hand them a $30,000 check, and you just screwed up everything I did.
Yeah.
That's why it's illegal. That's why it's a crime to ask. Anything more than 10-care says you have to pay, and once you file an application, you are 10-care application pending, and the law says the facility must treat that person from that day forward as if they have already been approved. What is in that language is so hard to understand. Well, what's hard to understand is why are we getting paid? And I had that conversation till I'm blue in the face. And they still haunt my clients and say, "Hey, I know what your attorney said, but you're up to $50,000 in arrears." And they're not in arrears. They're not supposed to pay it. The only time you're in arrears is as long as I'm on that, we're toward the end, I'll finish up with this. The only time they're in arrears is if they're pending for 3 or 4 months and only paying the patient estimated liability, which is their income, and the application gets denied. Now they go back to the day you filed and said, you owe us from then, and that's right. Not in my cases. I've never failed to get anybody eligible yet, and I don't think that's ever gonna happen, but I guess it's possible. I have to acknowledge that, but I doubt it. Then you owe it, okay? But we're not there yet. You can't ask for it now, and there's a reason why you can't ask for it. It would muck everything up. You know, I've involved the Tennant Care Ombudsman with that, and they have slapped them down. And I said, listen, if I get mad enough and have the time, I'll do something that you won't like. I mean, I'll charge you, I'll get the AG's office to charge you with a Tennant Care crime.
Yeah.
But I don't have the time to do that. I don't want to do that. I want to maintain a relationship with these folks. So I pointed out and tell them, hey, why don't you talk to your legal department before you push this any further, because you'll find out. And then usually it magically stops. So anyway,
That's about like I had a finance company to call me one time in April and wanted to know when I was going to make my June payment. I said, in June?
Well, we don't think your credit's very good. We'd like to have it way in advance.
Yeah.
It's like, well, I know I see what you'd like to have, but sorry, I don't pay for no service. I don't pay good money for no services yet.
That's right.
Anyway, again, real quick, kind of snuck up on us. The seminar's coming up March the 28th, which is 2 weeks from tomorrow, right here at the WLX radio station. That's a Saturday, 10 a.m. Wills, Trust in the Nursing Home. If you haven't signed up for that, if you haven't been to one of my live seminars, you might want to consider it. I get a lot of great reviews on them. People learn a lot, answers a lot of questions. So come to that. You call my office at 931-363-7222. That's Pierchoski Estate Law, Pierchoski Elder Law, 363-7222. Or go to my website, estateplanstand.com, and that'll give everything. So that just about brings us to the end, doesn't it?
That's it. Hey, appreciate it.
See you next Friday.
Well, Jeff will be back with you next Friday, but I'll be somewhere in the building.
Always a pleasure, LB.
All right, thank you. You too.